My name's Annie Moy. I'm a partner at Sharpe Pritchard, and I'm here today with my fellow partner, John Sharland, a specialist in local government law. And we're going to talk today about bias, predetermination, and pecuniary interests. Hi, John.
Hi.
So when you think about what we ordinarily understand by bias, you might think it's a concept that obviously applies to courts, to tribunals, but why should it be relevant when you're talking about the kinds of administrative decisions made by local authorities?
Well, with a lot of local government decisions, obviously, there are very important issues at stake. And if you think, for instance, of a major planning application, potentially there are millions of pounds involved. So the courts have taken the view that for those kind of decisions, the people who stand to gain or lose by them are entitled to have them decided on by a decision-making body that's free of bias.
Okay. And in the title, we talk about bias and predetermination. Are they the same thing, or are they two different concepts?
I think there is a difference between them. When you talk about bias, what you're talking about is a perception that the tribunal or decision-making body is biased. When you're talking about predetermination, what you mean is that somebody is approaching the process with a closed mind. So they're not making a real decision, because when they come to make the so-called decision, their mind is already made up.
Okay, so let's first look at the test for bias.
Yes, well, this derives from a 2004 House of Lords case called Porter and McGill.
Oh yes, the homes for votes.
Yes, exactly.
Yeah.
Well, this was the case that gave rise to the current test for bias. The auditor had to announce his provisional findings, and one of the arguments was that the way in which he approached this was biased, and this was the test that the House of Lords said should be applied.
Right. It looks like quite a vague test though, doesn't it? I'd have thought there's quite a lot of scope for argument about what a fair and reasonably well-informed observer might think.
Yes, you could say that, but it stood the test of time, and it's the sort of test that courts are used to applying.
Okay. And predetermination, so this is about approaching a decision with a closed mind.
Yes, exactly.
Okay. I'm conscious that one of the problems you get in the local government context is that if something big and important is happening in the local area, then as a local politician you're expected to form a view. You can't really keep quiet about it and say you haven't got an opinion. On the other hand, if you have gone around saying that you're for something or against it, then would people then say that you're biased and you shouldn't be involved in decision making as a member?
Well, yes, that's exactly the problem, because of course people do often try to challenge these decisions. And there was a case in 2004 called Giorgio and Enfield London Borough Council where this problem came up. And they had a body called the Conservation Advisory Group, where there were members who looked at planning applications before they went to planning committee for decision. And 3 members of that group who had supported applications as members of the group then subsequently sat as members of the planning committee that approved them. And in that case, the court said, because of their previous involvement, there was a possibility that a fair-minded observer would say that there was a real possibility of bias, and as a result quash the decision.
Right, because the decision makers had closed minds.
Yeah, that was the conclusion.
But that was 2004, so that was before Section 25 of the Localism Act 2011 came into force.
Yes, let's have a look at that.
Okay.
So this was to deal precisely with the issue we've just been talking about, saying that the fact that somebody has made public comments about something doesn't mean necessarily that they need to be excluded from the subsequent decision-making process.
And did the Localism Act make a difference?
Well, I think it has made a difference. There was a case in 2014 called IM Properties and Lichfield Borough Council, and in that one the leader of the relevant political group had sent an email talking about a 3-line whip and saying that members of the group should either vote in favour of the proposals or abstain, and this was about changes to the local plan strategy.
Right, and did they get away with that?
They got away with that, yes. The court said that, first of all, the email came within the ambit of Section 25, and second, that it wasn't in such strident terms that your fair-minded observer would conclude there was a real possibility of bias.
Okay, so does that remove the law of bias and predetermination from the local authority arena?
I don't think it does completely. If you've got a clear-cut case of a decision maker who was obviously had made their minds up before the decision needed to be taken, then I think in those circumstances the court would still quash it, yeah.
Okay, so as a local government officer, if you have a member who's determined to go ahead and vote, is there anything you could do to actually prevent them?
Well, you can't actually prevent them. I mean, you can only give advice, and then they would take a decision knowing that there was a real danger of it subsequently being subject to challenge, successful challenge in the courts.
Okay, so shall we turn now to members' interests?
Yeah, sure.
So this is a slightly different issue. I think councillors are obliged to ensure there's no conflict between their private interests and their duties as members, is that right?
That's right, yes. Obviously, I mean, that's been the situation for some considerable time, and councillors are expected to observe the Nolan principles of public life and ensure that there's no conflict between what they do as individuals and what they do as members, obviously to ensure that they're not as servants of the public getting gains for themselves as private individuals.
Okay. So let's have a look at this on the screen.
Yeah, so there's the kinds of things that would give rise to a conflict. That's really more or less what you would expect.
Okay. And what if members go ahead and take part in decisions which affect them?
Well, that's much worse than the decision just being quashed. You do so at the real risk of being prosecuted for a criminal offence and going to jail as a result.
Okay. So absolutely something that local government officers would need to be able to advise on.
Absolutely, yes.
All right. Well, thank you very much for your time, John.
Thank you, Annie.